Okay, it is 3 o'clock. We'll get this show on the road because I know you people are super busy and just scrambling to figure out what's going on in life. We actually had talked about doing this tomorrow or even Thursday, and just the volume of questions we're getting and kind of the changing situation with school closures and what do we have to do and all this, emergency resolutions and all this stuff. And so we are going ahead. Oh, we got to back up.
Thank you for reminding us.
That's why the table's here, because I get, so we just decided to go ahead and throw ourselves open to answer some questions. Let me say a couple of things at the top. Number one, you guys are doing awesome, right? You're not sleeping. We're getting emails from you all at 2, 3 in the morning. Take a beat. Really, you're doing a great job. You're gonna have critics. This is like the time to think about the quotation about the man in the arena. You guys are in there throwing punches and you're doing the best you can, so feel good about that. Number two, our job is not to have it be all unicorns and rainbows. Our job is to give you choices and then have you make the best decision you can based on legal compliance. So if you decide to pick one of the options that we talk about today and your neighbor decides to pick a different option, we don't judge, right? That's not our job. Our job is to give you all your choices and let you make decisions as you may. I think that involving boards in a lot of these decisions is important because in the end, they're going to be political decisions. And I don't think that is a lack of leadership. I think as administrators, you should make a recommendation, but then take it to your board. So that's kind of the 5,000-foot view. Last thing I'll say is way of introduction. There are 2 sets of laws that govern schools in the state. And you guys know this, but it's just good to remember the structure of how we work as a legal system. So one set of laws is state law, unemployment, Rule 10, Teacher Tenure Act. Those are all state laws, and those only apply in Nebraska. We have a whole nother set of federal laws, IDEA, employment discrimination, Family Medical Leave Act. Those are federal laws. And so when you have state politicians telling you that they're making changes to the law, just remember they can change state law and they're doing their damnedest to do it, but we have to keep track of federal law obligations too. And you'll see at several points as we answer your questions, that dichotomy comes into play.
The one thing I'd add is we appreciate that right now you're drinking out of a fire hose, and it's one of the reasons why we're doing these webinars, to get out the general information as efficiently as possible, because you have board meetings tonight, tomorrow morning, Friday that you're preparing for. But over the last several days, as the questions have been incoming, it just reminds me how important and how unique each individual district's situations are. So if you hear us say something today and you think that's a good idea, but now we need to execute it or I have some questions, absolutely call us, or if we're not your lawyer, call your school lawyer and talk about your specific circumstances with them, because the general stuff we talk about, it's going to be accurate, but there may be something about your board policy or your history or your details that make it really important to get specific advice for your situation. So just understand that what we're talking about today has some assumptions and generalizations, and you want to make sure if you're getting legal advice to make decisions on it, you're actually talking to a lawyer one-on-one.
Okay, so I think we had thought about 3 broad topics that we're going to kind of hit, and then after that, we'll just answer questions until you guys are sick of us. So the 3 broad topics we are getting questions on are, number 1, what should we do about educating our kids while we're closed? Number 2, what's this new thing about the Open Meetings Act? I cancel my meeting for tonight and just do a phone call. And then number 3, what's the story on personnel with the new laws involving unemployment and the federal law? So we're going to hit those 3 things fast, and we'll answer questions on those topics, and then we'll just throw it open. So let me start with educational services, because I think that's the most fast-moving thing, and really one of the reasons we decided to do this today. So I was on a webinar with special education directors this morning, and I'm like marching through the best legal advice I can give. And Amy Rohn, who is the new special education director at the state of Nebraska, Amy's here, and I just super shout out to Amy. She's been a great partner, and thank you. So Amy's here for rebuttal time. But in the middle of the webinar, Amy said, the commissioner believes that schools should be providing some sort of educational services to students while they're out. And those of you that saw me on the special ed call know that I was kind of like glitch. And so we have updated guidance. That's why Amy's here. She's shared with us kind of what the department's rolling out tomorrow. So here's what I think your choices are right now. You could do nothing. You could do nothing for next week until things settle out. You could decide to do nothing ever, and we'll talk about the risks. You could provide enrichment services only. And I think that's a really good choice to consider, and we'll talk about what that means. Or you could decide to provide full educational services, which includes full FAPE and special ed services. So the commissioner will not be happy if you do nothing for the entire time you're closed. But that's a choice that your board could make, and you live with the consequences. You could provide enrichment, and that choice has consequences, or you could do full educational services, and that has consequences. Fair enough? Do you guys want to talk about the call you run with the? Oh, Amy.
Yes.
So see, this is why this is the difference between a state administrator and us. Amy's like, or you could do all three. You could keep building and building, because of course she's Little Mary Sunshine, and we're the lawyers that are like, no, the bare minimum. So that's why I'm glad she's here.
Why do you hate children?
So let's start talking about the do nothing option, right? I think it would not be crazy to say we're going to take the next 2 weeks and pull a plan together instead of scrambling and providing not high quality educational services right now. I know that parents in town are like mad that their kids are driving them crazy and they don't have stuff to do. But giving yourselves 2 weeks to get yourself organized, I don't think that's a bad idea. Amy's
Or whatever amount of time.
Or whatever amount of time.
You need to.
Right.
Yeah.
Now, the reason I say 2
days.
weeks is because there are implications special ed wise after 10 days. But, if your district decides it's going to take them 3 weeks to get organized, call us and we can handle the implications of that. So I think that's a really good place to land. Like if you're meeting with your boards tonight, we're not doing anything tomorrow, but we're going to figure it out as time goes on. A more aggressive approach, I think your district could say we're not providing services ever. Amy's going to say, I'm going to tattle to the commissioner on that, and the commissioner's not going to like that. And if he refuses to give you your waiver of your 10,080 hours requirement, there's an appeal process, and you'll have to fight that fight if it comes to that. So that option still exists. I mean, they're not going to put you in jail. You're just going to have to deal with the consequences of that. So those are the do nothing options. Fair enough? I'm talking too much.
No, I think that's right.
So that's do nothing. Second option, provide enrichment. And I just want to take a second. Amy shared the guidance that they've got coming out tomorrow, which I think is going to reinforce and do a nice job of laying this out. But enrichment is, you're not necessarily teaching new standards. You're not necessarily moving through new curricula, but you're reinforcing and reteaching skills that kids already have, or doing things that are supplemental to skills that kids already have. So the easiest example for me is math, because I'm really bad at it. So if I'm a third grader and I have been learning my times tables and I know my times tables, if you send home Schoology or Brain Pop or whatever for me to keep practicing times tables and get better and better, and maybe even I got up through 12, so now you're going to add 13, 14, 15, I think that's enrichment. If, however, we were fixing to start division fourth quarter, and you teach division online, either through an app or through Zoom, that's education. And if you do education, then you have all the implications under special education law. So I think enrichment is probably where most of you are going to land, if I were predicting. I think that's where the department will be satisfied if you land. Amy's making kind of a face like this. I think, they always want a little bit more than we want, but I think we'll be okay with the department if we do enrichment activities. And then your last option is full educational services. But then you have a whole bunch of really difficult issues with special ed. Now, I want to drop a quick footnote. We keep blaming special ed for the reason why full education services isn't a great idea. And special ed is the most obvious reason, but there's a bunch of other things. If you say that we're going to do full educational services, here's other things that you and your board are going to have to think about. What are you doing about personnel? What if somebody gets sick? Do they have to burn sick leaves while they're teaching Zoom classes at home? What if their kids get sick and they step away from, so there's a whole kind of range of personnel issues that you have to consider. You have to consider, what do I have here? Oh, equity. What about the fact that, the 12-year-old is staying home with her little sister and mom is working because mom needs to work to buy groceries, and you're expecting a 12-year-old to get a 7-year-old online and doing her worksheets. I think there's some real economic equity issues separate and apart from special ed that I would be really troubled by if we're doing special ed. I mean, doing full education. And then our last issue is SIPA. Remember, the Children's Internet Privacy Protection Act requires us to make sure that we are not exposing children to content that's harmful to minors. If you're sending kids home with a Chromebook and having them access the internet through mom and dad's Wi-Fi, I don't know that we have a really robust filter, and so we have potential SIPA problems. So those are just a few of the things that we're worried about if you do full education.
Well, we talked about some other ones on Friday, which is the state statute that requires you to provide all resources and equipment necessary for students to access education. So with the restriction that says you can't get 10 people together, if you have 10 communities or 10 people in your community that don't have the internet, I don't think it's as simple as everybody that doesn't have the internet come to school. And so that's another complication here, is providing it is equity beyond even socioeconomic, for that matter. What if a kid's internet goes out that day? Do you owe makeup? Who knows what the infrastructure load's going to be on all these systems with people working from home? There's all sorts of other state law issues specific to practical complications. That's not to say that they should stop you by any stretch, but it is to say that you should be thinking about those in the time that you're taking to figure out what's our plan going to be.
Okay, so those are educational issues. We want to answer questions now or keep busting through the...
Keep going.
Okay, so second thing we want to talk about is open meetings, and I'm going to have Cody take the lead on that because I've been doing special ed and he's picked up this stuff.
Yeah, so one of the things that we're trying to do with this, and as we talk on the phone, is there's a lot of things going out there by Twitter and press release and things like that. And to the extent we can get actual, legal documents and interpret them and give you advice, we want to try and keep you up to speed as to where things stand. So you may have heard, you may not have heard, you may have been doing your day job, that the governor this morning issued an executive order that basically suspends or partially excuses for a temporary period of time the requirement that school boards, when they conduct their public meetings, meet in person, and enables you to have your school boards connect by video conference, telephone conference, or other electronic means. It's pretty specific about what it enables you to do and what it doesn't enable you to do. You have to, if you're going to do that, you have to make it accessible to the public and to the media. Our view is that this is different than the video conference, telephone conference rules that apply to ESUs, where you have to have somebody physically present at one of the sites where the public can get to. We think you can do this on Zoom and provide that login to the public or to members of the press. I think there's a bunch of different ways that you can do it, and you can tailor it to your own unique circumstances. If you have a Strive channel used for football games and you want to use that to make it available to the school board, I think you can do that. If you want to have a telephone conference that's listening in one of the places that people are at and just have a dial-in number, I think you can do that. If you want to do Zoom, I think you can do that. So there's a lot of ways that you can satisfy that and meet the requirements. I think you should talk to your school lawyer about your specific circumstances. And it also addressed some of those specifics. The other thing, though, that it made clear is that the other provisions of the Open Meeting Act continue to be enforced, and specifically cited out the notice requirements and the agenda requirements that are there. So we'll have more materials about what those should include, where the changes are, where they're the same. But just be aware that this does enable you to have your boards continue to play their leadership role, but have a little bit relaxed requirement of everybody being together in a small room.
I just want to hop in just and reinforce what Cody said about emergency stuff. Now, an emergency meeting excuses some of the notice and agenda requirements, but the executive order makes clear that this, it's not quote unquote an emergency for purposes of not having to give notice of your meeting. So I've gotten that question a lot.
Right. We're having meetings when an emergency has been declared. We're not having emergency meetings.
Right. That's a great way to put it.
And the other question, and again, this has to do with the continuum of events, right? Last Friday, we talked about a resolution authorizing the superintendent maybe to have permissible authority under the law, but broader than the board had traditionally delegated to a superintendent. And now we're getting, does this cure that? I think the answer is no. I think you still need that broadened authority. And there's a couple reasons why. Number one, with those notice requirements, you're still going to be required to have them out, 48 hours in advance, whatever your board practice is. And you can't change the agenda, more than 24 hours in advance unless it's an emergency. And again, this is an urgent situation. I don't know that it's an emergency for purposes of the scope of your agenda. And so there may be things that come up in a 24, 48, 36-hour period that your superintendent still needs to make a call, still needs to act in the best interest of the district. And a resolution that has already pre-authorized that, I think, is prudent, even if everybody's preferred practice would be, let's let the board, meet in 3 or 4 days to decide it. So we still think you need both. And again, we are working with districts regularly on tailoring those for what the board wants those to say.
So we're going to turn now to some of the stuff you've been hearing in the news, and then also the press conference yesterday about the unemployment. When we're answering these questions, we'll come back to some of the each of these points too. So we want we're trying to figure out, do we answer questions at each section? But I think it's just going to be easier to kind of truck through them as we go. So real quickly, the first thing here is the unemployment. If you listened to the press conference yesterday, basically the governor and the commissioner of the Department of Labor said three things, which I think are important. Number one, they're going to waive the 1 week wait period for unemployment. So if you are truly laid off from your job, you typically have or if you're fired, you typically have a 1 week wait period, even if you're otherwise perfectly eligible for unemployment. Waiving that in light of things like, a 2 week quarantine period for coronavirus makes some sense. The other thing they said is they're going to waive, or at least they've promised to waive, the requirement that you generally demonstrate that you're seeking other employment. That is important for the third point, which we'll talk about, which is they're going to make it available to folks. From my understanding of what they said, and I'll talk about, we need to see the executive order first, but they're going to make it available to folks that have not actually been laid off or have not been fired because of leave required by the coronavirus due to closures of the businesses, for example. So all the bars and restaurants and things that you're hearing about going to pick up only, right? They have an entire wait staff that probably won't be working. They're still employed, but they may not be getting paid by that entity. They are able to apply. They said a 7 to 10 day period before you get a check, but they're going to treat your continued employment as though you've been laid off. That's kind of how they talked about it in the press conference. The reason that I'm sort of hedging on all this stuff is we have not yet seen the executive order. So Cody is literally holding the executive order from the governor's office about the open meeting stuff, and it says shall apply today through May 31st, right? We don't have that document yet. At least I haven't seen it if it's out. So before we're that comfortable saying to schools, hey, a totally viable option is to let your folks apply for unemployment, it could be, it very well could be, but we're waiting to see what that actually says first, because there are some things to sort through, not least of which is, what if you're continuing health insurance benefits for those staff members? That then render them ineligible compared to employers that don't offer those sorts of benefits. There's a lot of stuff to sort through. The other big piece of this, I think, is, and what they promised, is if somebody applies and they work at XYZ public schools because they're a paraprofessional who is not able to work during the closure, they're telling us right now, right, that the money to pay that person's unemployment is not going to come from XYZ public schools, right, like they normally send you the bill for that, but that it's going to come from the community trust, right, that the amount, the pool that we've got to pay folks, not from a specific employer. We're going to need to see that in writing, because if you've ever heard us talk about unemployment issues, you kind of know our thoughts on how difficult it is, or the extent to which they're pro-employee, which we can very much appreciate. Until I see that a school is not going to be on the hook for that, I'm just not going to trust that that's how it's going to be. So if the EO comes out and we see it, we'll certainly let you know what we have in terms of thoughts on that. But this idea that let's just stop everything and rely on unemployment, that could be a perfectly viable strategy. We don't know if it is yet.
So what I'd say is, as things are evolving and it feels like it's different than we talked about Friday, until we see it in writing, it's not different. So if you're thinking about, we closed yesterday, what do I do about classified staff, either retaining them to make sure they don't go to another employer or making sure that we're getting compensation to them? We think things like a return to work agreement or any of those other options we talked on Friday are still viable. If your meeting's in the next few days, still plan for it. Let us know. We can get you that return to work agreement. We can talk about your options. There's NPERS ramifications to it. It's a little bit complicated legally, but the point is you have tools to address it based on how things are now. I think it's prudent to not plan for something that's been forecast until you've seen it right.
And let me just pop in and say the unemployment stuff and the retirement stuff that's a huge issue. And Orrin Hill, who's the general legal counsel at the system, called me yesterday at 5 till 5, and I was on the phone until I don't know when. I called him this morning before I hopped on my special ed Zoom. Long story short, we haven't made connections. So that's the other great unknown. If someone goes to unemployment, I am assuming that's not credible service on the system. And that can have is that going to be a break in service? We don't know how the system is going to treat it. And so I'm real nervous about NEPERS, not being unkind, but NEPERS has obligations federally that they can't waive with an executive order, just like we have special ed obligations that the commissioner can't waive with the stroke of a pen. So that's another thing to worry about.
Yeah.
So I think that's kind of our pre-planned. Do you need to? Oh, I'm sorry. Yes. Okay. A lot of questions too about this federal law that passed the House of Representatives. we've been hearing it talked about. It's talked about in the news, like the basically FMLA on steroids. So we want to make a couple of points here. I'll let Cody make another one, but functionally, we know it's passed the House. We don't know exactly, I don't think, based on some other kind of rumblings out there, if the House has made some changes to that prior to sending it to the Senate. Even if it goes to the Senate and is approved by the Senate, they're still going to have to reconcile any differences there. And there's going to be several steps in the process. Maybe in the time we're talking, the Senate will have passed it and it'll be signed by tonight. I don't know. But if you're also tailoring your plans about what you're going to do with staff based on this federal law, be a little bit careful and wary, as you should always be, until you see it perfectly articulated in writing. We're aware of it. We're going to keep looking at it. I've read most of HR 6201. It is what you're seeing in the news, but until we see that, yes, it's passed the House, yes, it's signed by the president, what I read could be functionally meaningless, right? Because they can always change that as it goes.
Yeah, so one thing that's interesting, again, on the draft, if it passes in its current form and President Trump signs it, so if, but if it does, this additional FMLA leave is going to apply to businesses with 300 people or less, including public entities.
500.
Excuse me, 500 people or less, including public entities. But what it changes is the requirement of schools 50 people or less would still be subject to this new rule, okay? So you might have heard about us talk about it before, right? All schools are subject to FMLA. Some of you schools that don't have at least 50 warm bodies regularly on the payroll, when that employee goes and seeks FMLA leave, they're not eligible for the FMLA leave because of the fact that you don't have 50 warm bodies regularly on the payroll. But even if you have 40, and even if they wouldn't get regular FMLA leave, they may be entitled to the leave that's contemplated in this pending legislation. So just when you hear that, when you hear FMLA on steroids, don't think, nope, that's not us. We didn't do it for PAPACA. It's not, we count payroll differently. It still may apply to you. Again, that's all tentative, but don't check out on it.
Okay, stump the idiot.
Questions. So we're going to start with what's on the chat, I think. And that's been a lot of stuff coming in. Then we'll move over to the questions you all have put into the Google Doc. I want to make sure we've got all those updated. So, okay. Got the volume issue sorted out. That's good. First question. Did the commissioner already give us all a waiver of the 1080 requirement?
No, he is not. He said he was going to ask us to prom. We bought a prom dress, but he has not made the promposal yet.
That sounds awfully specific.
I'm just telling you. No, I'm old. We didn't do that kind of stuff.
Listen,
when I was
Karen,
in high
we
school.
canceled prom, so I don't,
Yeah,
I don't know
true.
what to tell you.
I shouldn't make prom jokes. So here's how it works. Rule 10 specifically has a provision that says, if you are in extraordinary circumstances, you can apply to the commissioner for a waiver of the 1,080 hours requirement, and the commissioner may grant it in his or her discretion. So we're all going to have to make some sort of mass application. I'm assuming the department will have like something on the portal that we upload. But he is going to, what are you laughing at? It's not the portal. Amy's laughing at me. So so we're going to have to, there's no hiding in this room. It's because you're not on the camera. So we're all going to have to ask for it. So no, he has promised that he's going to waive it, but he has not yet provided that waiver.
Clarification. Can enrichment only be review as opposed to teaching new materials? So I want to say something real quick because the commissioner was nice enough to hop on a call with Steve and Amy, with Brian Halstead, with several of us that are trying to help get this stuff sorted out, to ask what are the questions that we need answered. And I think that's a fair thing for the commissioner to ask. And to the extent that we've got questions like, what is the difference between, where's the line? If we assume over here is we're going to do nothing and we're going to tell our people to stay home and like it, and then somewhere right here is the line of all the enrichment activities we can provide, and then somewhere right here we get into what the feds and their guidance talked about as educational services, where exactly on this spectrum is that line? That's the question that we're getting from a lot of you. The short answer is, I think we're going to get some guidance from the department. I know we've gotten a little bit of definitional, or at least a stab at definitional guidance from the feds. But that's the line that you need to know, in my opinion, before you take any real concrete steps forward, no matter where you land, or as Amy notes, no matter where, or if you're going to treat this incrementally. So maybe for 5 days, we are going to do nothing, or until we reach our 10 days of closure and we have special education considerations for change of placement. Then maybe we move into things that look more like enrichment activities, and maybe somewhere then we move on and feel confident in what we have to do for providing educational services. But where that line is one of the questions that they are endeavoring in good faith to answer at the department, including talking to the federal folks about clarity on what exactly they're expecting as well. So I don't know if I misstated that, Amy, but that line is precise. The one that Sam asked about is precisely the one that we as school lawyers are trained to freak out about. And the Commissioner of Education is trained to blow past because he wants what's best for kids. That's not to say that there's any disagreement here about that there should be a line. The question really is making sure that the stuff that you have to answer for up to it and afterwards is at least somewhat clear.
And I'm just gonna hop onto that because here's the problem. The commissioner can try to suspend parts of Rule 55 or Rule 51. I'm not sure he can suspend Rule 51, but we'll let the commissioner do commissioner things. That does not change what OCR does when they come in and do an OCR investigation. And remember, this is the same OCR that comes in with a tape measure and measures to see whether your girls and boys locker rooms are exactly the same number of inches. So I've done a lot of OCR investigations, friends, and I'm not super jazzed about telling OCR that don't worry, we came close enough.
What was on their webinar from today?
I was just hopping to that. They've also released Steve Williams is also in here, and now he's heckling for other reasons, so that's no bueno. So OSEP and OCR have released 3 different written guidances about coronavirus since this whole thing blew up. 2 of the 3 are almost entirely focused on don't discriminate against disabled people. So I think that tells you where their head is at. Their head is not scramble to get some services to everybody and then we'll worry about making it up on the backside. They're saying your #1 concern should be anti-discrimination. They chose today to release a webinar on making sure that all of your websites are accessible to the visually impaired.
And all of your e-learning activities.
And all of your, everything is, I mean, that, then they said, well, you should contact a vendor to make sure that, that the coding is all there. And a mechanical check is not enough. You need an actual coder to look at it. That was in their 7-minute webinar they sent out today. So I guess what I'm saying is I'm not super confident that OSIP and OCR are going to be forgiving. And then the last thing I'll tell you is that is entirely separate from whether or not a family can sue you. A family can sue you in due process under Rule 55 and the commissioner can waive that. They can also sue you in federal court. They can sue you for violations of the Americans with Disabilities Act or the Section 504 of the Rehabilitation Act, in addition to being able to bring special ed litigation. So I guess I'm just saying, I know that doing what's right for kids and don't let the lawyers slow you down feels right, but there's a lot of law here. So that brings me back to the difference between enrichment and education. We're going to be trying to convince OCR and a parent's lawyer of that, not necessarily NDE of that. I have every confidence that NDE will give us guidance and they're not going to play gotcha.
And they're not resting on their laurels about changing hearts and minds at the federal level, right? There are other states that are dealing with this same, we're not alone. And we've got some nice poll based on where people are in terms of ranking federally, like, hey, I'm going to call this person, that person. So
but I'll just tell you, there are disability advocates out there because I just went and fell down that rabbit hole. There are disability advocates out there right now saying, we are going to sue you for not providing our kid full special education services, and we don't care what you're doing for gen ed. Our kids trump everybody else. So don't think that there's not that argument out there. So they're going to release guidance from the department. Amy showed me a draft. It looks really good. I think that will answer your specific question, Sam. Basically, and I'm looking at Amy now, basically we should not be moving through new standards. Is that what that would be enrichment is not moving through new standards. Is that fair?
Enrichment, a student should be able to do on their own.
And Amy says enrichment a student should be able to do on their own as opposed to needing instruction. Yeah. That's another good rule of thumb to keep in your brain. That's really good. Okay, so that's the best we can do.
That's it. Yeah. So Brent asked a similar question. Is it education if we don't grade it or require it to be turned in? And we're getting this question a ton. Like, do we send, if we stopped on lesson 10.2, do we send lessons 10.3 through 12 that we would have covered and say, go get it, everyone? I mean, that's a question I've gotten many times.
I think that might run afoul of what we just talked about in terms of if they needed instruction and if it was something they hadn't covered before, it might be on the wrong side of the line.
Are we going to reteach it when they come back though?
So this is the stuff that you're understandably struggling with, right? And even though Amy articulated a really good way of thinking about it, does it require instruction? It normally does. We normally wouldn't just hand it to them and then walk out of the room. But are we in different times? And I think that's why getting some clarity on this before deciding to send that packet or not send that packet is important.
You're closer to enrichment if you don't grade it. You're closer to enrichment if you
No
don't
credit.
require it.
Yeah.
I don't think photocopying the next chunk of the workbook, well, geez, let's not even think about copyright. I don't think sending home the next chunk of the workbook is automatically education, but Cody's right, you're getting closer
Well,
to that
and
line.
here's the other thing that we're not really talking about. If we're sending that packet home, even calling it enrichment activities, that may have a special education implication. That does not answer 504 and ADA
Yes.
questions, right? So
Yes.
if you have a student who is visually impaired
Yes,
and on an IEP, we don't remove the 504 and ADA obligations just because we're choosing to send home the packet, right? We still have to make sure that and that's what OCR is talking about in its webinar about website accessibility for e-learning, right?
Yep.
Even a paper packet going home, and you got the best parents in the world that they're going to sit down and do whatever they can to commit their visually impaired child to mastering that material. We may have committed a violation by simply sending it home and not making sure it's accessible to the extent it would be to typically developing peers.
the feds are very, very clear. If you do it, whatever it is, it must be equally accessible to everyone.
It has to be the same stuff. It's not like an alternative curriculum you can send.
All right, another really good question. The governor and commissioner both used the phrase getting students ready for the next grade level or course. This seems to at least imply some new content is necessary. Brett follows up and says, I agree, heard we're supposed to get them ready for next year as best we can. Where does that fall within what we're talking about here?
I think it hits the nail on the head. I think that's the tension.
I think politicians and leaders speak in terms of what they hope is true. And I think lawyers speak in terms of what you have to do to comply with the law. How's that for dancing around?
Amy, do you want to tap dance here? Is that?
So the SEA's role is to help school districts provide for students to get them grade to grade or progression to progression, right? Because for some kids, students with disabilities, it might not be grade to grade. It might be concept to concept. So I think in these terms, that's what we, commissioner and governor who support guiding schools would tell you, and we would rely on the attorneys to tell districts how to do it right.
Yeah.
No pressure.
So just to be clear, if we know we're on the enrichment side, that does not trigger services under the IDEA. Now we talked about, but that doesn't eliminate ADA and 504, but
I think that's right. If you are on the enrichment side, the guidance from OSEP has been clear that you would not owe, for example, service minutes, OT, PT, instruction by someone that holds a special education certificate. So I think if you're firmly in enrichment land, you do not owe FAPE obligations, but you do have accessibility obligations. Think of it like this. If you send home packets, you're not going to go by everybody's house except the kid in the wheelchair, because you're not going to say to the kid in the wheelchair, sorry, even though you're perfectly capable of doing this packet, we're not going to give it to you. So the blind kid, the hearing impaired kid, the student who has some kind of physical impairment so they can't use a pencil and pen, those would all be kinds of accessibility issues that you still need to address under 504 and the ADA. But you wouldn't need to send the therapist home for the kid that has mental health services as part of his or her IEP. I don't think, because you won't know those service minutes. Amy's making a face, so I'm double checking.
I'm going back. I'm just thinking you're fine.
Okay, all right, just making sure we're all gonna be on the same page, so we're good.
Ruth just comments that the rural internet for them is not working well today. That's one of those practical considerations that's not really a question, but that we're
Get out
thinking
there and
about.
fix it, Ruth. Why don't you love children? Sorry.
We're gonna, come on, Karen. Okay, so you mentioned if we have to bring students in, can we bring in, say, 5 to 9 students at a time if we don't violate the 10 student rule or the 10 people together rule? I want to say something about that and then defer the other question to Karen or Cody. The governor put out additional clarification, I would say, on what that 10-person rule is really meant to do, clarifying that that is not what we call an emergency health directive. So if a city, like Omaha, for example, says, we're going to close bars and restaurants, you cannot be open, that a local health department can actually declare, and it has the authority of law, right? It's a class 5 misdemeanor. The governor released guidance to law enforcement today saying that's a misdemeanor if you violate one of those actual health enforcement directives. What the governor was saying yesterday was reiterating the CDC's recommendation or guidance or saying you should do this of not get 10 people together or more. So keep those two things different in your mind. If your county says that we are going to declare, right, one of these health regulations or health ordinances that because of this, you can't have 10 people together, yes, you could be arrested for that. My understanding is we have not done that yet, at least on the statewide level, but you definitely have to check with your local health folks on if they have or plan to put something in place. Because as we've been telling you the whole time, how you close and what the people around you, including at the state, DHHS, and your local health folks do, can dictate the way that you operate when you're closed, right? So make sure that you're not conflating those two things.
As far as bringing kids in 5 and 6 at a time, here is my concern. Remember that OSER says that your obligations to provide FAPE are sort of suspended if you are closed. If we're bringing kiddos in shifts, are we closed? I don't know that we are. And so then that raises a whole bunch of questions. Like that would implicate entire FAPE obligations. That would implicate early childhood. That would implicate supplemental services like OT, PT, mental health. So I'm not a big fan of, oh, jeepers, yes, that's huge. Yeah, English language learners services if you're not closed. So if we're cycling people in and out of the building, that we're cycling students in and out of the building, that feels like we're not closed, and I think that has some pretty big implications.
And I get the question, right? Which
Right.
is in our community, we got a lot of folks that aren't going to have the internet if we want to move to e-learning. How do we deal with that other than paying for all of their internet? And there may not be a great answer for that.
And what I would say, it's not sped, but we've gotten awesome questions from clients all over the state that are being great leaders that are looking for guidance, thirsting for guidance from leaders at the regional and state level. And they're also making their own individual decisions. School boards are making their own individual decisions to keep the health and safety of their students and their communities paramount, even if they're not directed to by the CDC or public health officials or governors. So what I'd say is when you're worried about making academic progress, even if somebody hasn't told you to, think about having 5 or 6 kids come through every 20 minutes and the sanitization and what can a custodian do? And it's important to get through those 20 minutes of reading instruction on that Tuesday. But how does that balance with your obligation to keep kids safe, right? And so, it's not an easy answer. I'll use a phrase that the governor used throughout our call today. You have to thread a needle sometimes, but I wouldn't punt on the health and safety stuff so much to other people that now you just have a thumb on the scale for, making adequate progress.
Yeah. This is a really good question from Corey in Waverly. It is one thing to not meet the 1,080-hour requirement. However, we've got a board policy on graduation requirements. Does our board need to take action on waiving those requirements so our seniors can actually graduate this year?
I believe eventually every board is going to have to do that. I think it is premature. I understand. I have had 2 high school kids graduate. I got new granite countertops, a new carpet. I understand graduation is a big deal. We had the Margarita Man. It was a great party. So I get it, but I think I know that those parents are calling you saying, is my kid going to graduate high school? And the short answer is yes. And the longer answer is we just don't know all the details yet. So yes, I believe your board's, Corey, I believe your board is going to have to suspend that policy. But I think let's wait and see how things play out. I still have a hope that we're going to find a vaccine and be back in school in 3 weeks. And I can have that hope. Don't take that from me.
Yes.
So,
the gloves are coming off here in the KSB classroom. Yes, I think you're eventually,
Corey, yes.
Part of that, Corey, is going to depend on what happens, either guidance from the state down about are we freezing grades at the 3rd quarter? Are we going to change this into a pass-fail system and provide 2 weeks in the summer for those kids who were failing to try to get to pass level? I think a lot of that's going to be impacted by that. Understanding having a graduation ceremony is different than handing them the piece of paper. I understand how emotionally it's not, but it is legally. Yes. So, okay, is there any option that allows us to provide the opportunity for students to interact with new content without calling it full educational services? This kind of gets back to the packet question. So wait to read the guidance before you decide, but if the idea is, especially for a kid who's struggling, are they just going to then have less access to, yeah.
Just remember, so they're going to fall further behind, right? That's the fear.
Yeah, Brad Best asked a good question. Not only the requirements for graduation, but credits per subject area. As a commissioner, would they be waiving those requirements at least for seniors? The commissioners referenced that. I don't know the answer to that. I'm assuming so, but
I believe he will. based on what Matt's saying, I'm looking at Amy to see if he said anything specifically about that to you or the leadership team.
But I heard what you both heard.
Yeah. Next question, the governor's executive order regarding board meetings. Is this specific to schools or ESUs and that sort of thing? So
No.
I get, it's so difficult to follow all this because some of these statutes apply to schools and some to ESUs and some to both and some to not. But I'll let Cody answer that. I don't
No, it
think so.
applies to all governing bodies that are defined in section 84-1409. And it also applies to all public meetings. So it's not just limited to school.
Oh my gosh, your Americanism, your Committee on American Civics Subcommittee can meet telephonically.
Do it now.
You can't, right? It's all public bodies as that's defined in, for every cloud, there's a silver lining. Okay, all right.
So I think that question probably comes from somebody that's an ESU that isn't in multiple counties. So that will apply. If you're an ESU that can't meet telephonically, you can meet telephonically. Yeah. Okay.
Okay. What if we choose to have a meeting with all board members in attendance? Do we go by the 10-person rule or not? I think that goes back to what Cody says. Unless your local folks or the state say, no, this is now a health directive or whatever the heck that's called, then I think the answer is no.
I'm getting heckled in person and via text. I love you people a lot.
She's not coughing on Cody as much.
But
Okay.
what I would say is this executive order maybe cleans that up, right? If you want to get together in a big room like this and still have the 6 board members and the superintendent face to face, 6 feet apart, I think you can do that. And now I think you can have a camera in there and then stream it into the video next door or just on something remote and say, that's the access to the public in the meeting. That we can all be in the same room if we want, but we don't have to let the public in now. That's one of the takeaways from the executive order.
Yep. Okay. Any idea, Adam Patrick asked, any idea when the executive order is expected out? I'm assuming that's when we were talking about the unemployment piece. No. I've talked to several people, including a couple state senators who are also anxiously awaiting that executive order. These things are tough, right? Because they got to, unlike the Open Meetings Act, where they had to slog through exactly 2 statutes to get that EO in place, they're literally kind of opening up and changing the definition of eligible employee under the unemployment stuff. So they're necessarily probably taking some time on that.
I should clarify one thing I just said about all the board being in one room. I still think you'd have to have at least some people participating by video conference or telephone conference. So maybe 5 of the 6 members or something.
Can we live stream the board meeting and restrict meeting attendance? Yeah, that's the question. I think the availability piece is something, Darren, that we're going to be talking about. And if you want to do this, you're going to have to talk to your school lawyer about exactly how. If that's Strive and the ability for people to access Strive versus Zoom, are you going to allow public comment? Do you have to allow public comment? How are you going to allow public comment? That's all stuff that, yeah, the answer might be no, but you need to be thinking about. So what about substitute teachers applying for unemployment? So
It depends on what the order says. We
I
haven't
was
seen
going
the
to
order.
say, normally the answer would be no.
So that's
because-
from, I'm sorry, go ahead.
Yep, no, go ahead.
Yeah, that's Brett Richards. So I think normally the answer is no if they have some sort of assurance of continued employment as a substitute. If they're going to waive that because you can remain common law employed, I'm assuming if they'll waive it for anybody, they'd waive it for a substitute teacher because they have less assurance in like a para over the summer, which is how we typically think of those things. But that's a really good question, Brett. I think schools struggling with, Bobby, we need bus drivers who are not full-time and substitutes just as badly. So should we pay them during the break? That may be a solution once we see the executive order. It's a good question. Yeah, what about pay for a contracted long-term sub, assuming you're talking about somebody subbing for a teacher?
I believe everyone agrees that that person is not entitled to be paid under, do you agree with that, Steve? You're making a face. Under the school closure? A sub is not a teacher, right?
That's why I'm breathing. A sub is not a teacher.
And that's what Maddie, even the union, executive director of the union said that. So I don't think a long-term sub gets paid while the school is closed. So I think he or she would apply for unemployment.
I think they also don't have usual salaries as that's defined in that statute. So there's just a lot of ambiguity in a statute that was written in 1919. So resolution to pay classified staff during short-term closure. This is a question that we've been getting a lot. Let me just say this. The difference between a resolution and a motion is nothing legally. Everything you could put in a resolution, you can pass by a motion, and you can pass a resolution by a motion vote. So the person down the road passed a resolution that said they could pay staff. Those terms are being circled inartfully, and that's not anybody's fault. There's just a ton of shit out there right now. I get that.
That's a term of art.
But keep in mind, yeah, a ton of shit, right, Steve? But keep in mind that what we're talking about here in terms of paying classified staff is probably something more than just pay them, right? Now, there are some schools doing that, and I appreciate taking that, whatever risk exists in that. But something like a return to work agreement or a system where we're going to actually have them come in and work as often as possible, so we're paying them to sit on the ready for that, that's different than pay them and don't have anything else involved in that decision. And I think that context is important for if there is a fight about the constitutionality and legality of that. So that's what I'd say.
I'll just hop in on one small thing, resolution versus motion, that matters a lot in parliamentary procedures. So if your FFA kids won Parley Pro this year, but we don't have to follow parliamentary procedure, and this is one of the reasons why we recommend that you not.
Right. How does FMLA work during an indefinite disclosure for staff that's currently using it and others that would otherwise start using it during the closure? That's Damon. That's a really good question.
I believe staff members who are on I'll do this one and then you take, we're gonna start. On FMLA are not, their FMLA continues to be burnt because they are not available for work if we opened tomorrow. And again, I believe, I know that's the right answer legally. That's also the right answer that the union is telling their members. So I don't think you're gonna get any pushback from the person that's on maternity leave about why she is burning her FMLA still, even though the school closed. Now, if you're gonna start FMLA leave, I think it's the same answer.
During closure.
So
The planned leave, I mean, here's your.
The wrinkle is FMLA in a traditional situation doesn't provide pay or any other benefits. It is basically an excuse to be away from work to not lose your job. You know, if the school's closed and you're not having certificated staff do anything and the statute guarantees that they're going to be paid, and ordinarily you'd force them on FMLA leave to burn the 12 weeks,
They're talking about burning their sick days. So
Yeah,
that's
yeah.
what they really care
Well,
about.
so here's the question. If you're expecting staff to do work and that person can't, then I think you've got a better argument that they are required to follow your FMLA policy in full, right? Which would mean burning their sick leave at the same time because they're not ready, willing, and able to report to work by virtue of the fact they didn't challenge your designation of them being FMLA eligible. So to some extent, it matters what you're having those staff do and whether they started it before or after your closure. Because somebody who was finishing up a leave may suddenly say, oh, good news, I had another 2 weeks left in my paternity leave. Guess what? I'm ready to come back the same day you close. Yeah. That seems weaselly, right? But remember, they have discretion over that type of thing. So you got to roll with those punches a bit. That you have to get legal advice on this question because it truly does matter a lot what you've dedicated those staff to be doing
That's right.
during any of those times.
and like, you know, it's similar to like if somebody, say someone has a baby July 1 ordinarily, and they're not the FFA teacher, they're not expected to be working, their FMLA leave wouldn't start until their duty days start at the beginning of the contract year ordinarily. And so here it really depends on who the staff member is. Are they classified as certificated? What's the basis for the closure, right? This is why we ask. For example, we heard an ESU was ordered to close by a public health department earlier this week, and then you find out, no, all the schools in the ESU got together and made a group decision to voluntarily close, right? Well, that may be a distinction without a difference from a practical standpoint for the school, but it matters a lot legally. One of those would be under FMLA leave and other sorts of things. So the basis for the closure, the expectations for the staff, even if they're not actually doing anything, are they on call, right? Like that's going to matter for some of these employment issues.
Yeah. Let's see. Does the return to work agreement blanket cover all non-certificated staff, or should we specify by job category? So I've gotten this one a lot. The short answer is you can if you want to. Because I think just like you don't have to pay classified staff, not every para has to make the same amount. I get from the political standpoint why you do. But just like employing classified staff that aren't members of, now if you collectively bargain with those staff, if you're one of the handful of schools that collectively bargain with paras and custodial staff and your kitchen staff, that's a different answer. But for the vast majority of you out there, there's no requirement to have them on synchronized contracts in the first place. So I think you can use differentiated contracts for something like a return to work agreement. And that can be based, Justin, the question that asked the question, I think that can also be based for all of you that have asked on this, on what you actually expect they'll be able to do during the break. You may not give your custodial staff this agreement whatsoever because you're actually expecting to fully employ them. You get paid the big bucks to deal with the politics of why do I have to work while all those paras are sitting at home. I don't begrudge you that political discussion, but that's the law is pretty clear on that.
And also I would say that, you know, again, you have the political issue, but you should, once the board authorizes superintendent to use the return to work agreement, I don't think that means that you have to then, you know, from a practical standpoint, apply it to everybody, right? Maybe 80% of your staff is the valuable ones you want to retain and not have to go get a job at the local co-op. But if 20% isn't, I don't think you're obligated by law to give them the same deal, assuming it's at-will employment, you have the latitude to negotiate the terms separately, you're not subject to collective
All
bargaining.
right,
We got a good question about how executive session fits into the new executive order. What I would say is that's a great practical question. I don't think there's anything in the order that precludes it. I think you're gonna have to think about, okay, we're on a Zoom call. We got a motion to go on an executive session. Is there a way to mute everybody in the video feed? Is there a way to keep that one going and all the board members log off and start a companion Zoom session and have the confidential conversation there and then leave and go back? I would say that in addition to always having areas for improvement in minutes, this is going to be a crucial one that you record exactly what you did, what the channels of communication were, who had access, when did they not have access, in addition to when you went in and went out of closed session. So whoever asked that, if you have more questions about that, we're happy to talk about the details, but I don't think on its face that there's anything in the order that precludes you from also conducting those executive sessions by video or teleconference.
Can we provide instruction to 712, but enrichment only for K-6, or is it an entire district decision?
I asked an expert at the Department of Education about whether we could bust out by grade level. My question was, can we provide just seniors? I believe, and I'm looking to see if, I don't think OSERS has said anything new. I believe that how do I say this? I will fight like hell to defend you. I think we have good arguments. If you say we're providing 712 services, but not K6. The commissioner won't like it, but I will fight for you. But remember that if you're gonna do 712 services, 100% you're gonna have to do 712 FAPE. And then I think we would win on K6 FAPE. I think we would win, but that question has not been squarely answered. Anything you wanna say on that? She's like, I'm touching that one.
If we have a limited amount of teachers working from home on enrichment, do you recommend we have them at least track their time counting toward their contract days? I think, sorry,
Go ahead.
I think you have the latitude to treat it how you want. I mean,
I think you absolutely fundamentally have to track those contract days, because whatever happens from now until the end of this thing, you're not going to know how many of those 185 you're going to need or not need. You should be tracking them, because I'll tell you this much, and when Maddie Fennell said this the other night, she's exactly right. Those teachers are tracking them.
Yep.
And that's appropriate. They've signed up for it. It's fair for them to account for those, and I think it's fair for you to be able to account for those, and having a joint system makes sense to me, to avoid that question 6 months from now or 3 weeks from now when we're trying to figure it out.
A long-winded way to say yes.
my point is the granularity that, you know, you can have them check in online and check out at the end of the day or hour. That's up to you in terms of how you're managing what they're doing.
But if you're having them hop on for an hour Zoom once a day, I believe that's a duty day based on how the commission has interpreted duty days. So if I was on a board, I want to get my money's worth.
If we are doing enrichment and we have students who are missing assignments from that work while we're in session, can they do it and have it be graded?
That was a question I got this morning, and there's a companion question. What about seniors who are failing? Can we go back and teach the things that they were failing that we've already covered? I'm going to take the position that is enrichment because we're not moving through new standards. What do you say? You disagree with me?
I know I do.
Yeah. So when in doubt, get permission. You may get forgiveness, not permission. So if we've taught the content in the classroom and we're going back and reteaching, to me, that's enrichment. That's solidifying skills, not giving new things. And so that's kind of what the district I talked to this morning, I think, is going to do with the handful of seniors that they had that were failing. They're going to go back and try to at least plump up the things that had their grades down to failing so that they can be passing as of closure date.
How about creating contingency plans for students with IEPs? Can you give any guidance on what those should look like?
So when we released our blog post last Monday, and based on the OSERS guidance on swine flu and even in the stuff that came out later, there was talk about contingency plans. Call families of students with special needs and talk about what it's going to look like if we close. Well, by Friday, we'll all be past that. So I don't know that contingency plans are really, I think it's kind of a moot point. Now we could talk about.
Let's reframe Chris's question of we're going to provide educational services during a closure. What do we have to do for all those IEPs and 504s?
You are going to have, so if the question is we're going to provide services during a closure, what do we have to do for 504s and IEPs? You're going to have to amend the IEP because that's going to be a change in educational placement. You can do that amendment with a written agreement and talk to your special ed director. Is that Chris? Is that a special ed person?
No.
So you're going to want to talk to your special ed director for help in how you have to do that. You're going to have to send prior written notice. You're going to have to send prior written notice to every single special ed family, no matter what. Everybody who's listening is going to have to send out a bunch of prior written notices. And so then if the family doesn't agree to amend without a meeting, you're going to have to hold an IEP meeting. And you can do that telephonically now, but you are going to have to meet. And then when school starts again, I think for every kid who has an IEP, we're going to have to talk about whether that kid needs compensatory ed to recover lost skills.
The other thing, and this is a question I got, what if we had 90% of families agree to amend without a meeting? 9% of families agree over a telephonic meeting because they just wanted clarity. One family says, nope, you will be here serving my child in our home tomorrow, or I'm not going to agree. You still have that decision to make as the IEP team. Inform the parents of that and provide prior written notice for what your IEP is during the closure and what services will be.
Yep.
That doesn't, you can't just decide, well, you didn't jump on board, we're not going to serve you, right? It's the same. If the family's difficult and won't agree, your team can still decide, and their option is to file for due process and not stop you from serving based on what the team believes to be appropriate.
Or file an OCR complaint.
Or file an OCR complaint, yeah. Okay, what about dual credit courses?
This is you,
So
Robert.
this is the big question. I believe that the firewall between enrichment activity and not providing anything in educational services, if you are saying to students that are taking dual credit classes, we, the school, are doing X, that is not going to guarantee your college credit. So we are giving you, here's the liaison at the college to contact. Here's the professor at the college to contact. Contact them and tell them you want to continue the class because UNK or whoever it is doing all of their classes electronically. Even if you had kids who were driving to the brick and mortar and not doing online dual credit already, I believe you can do that because there's nobody in the school, your school district, who's actually providing instruction to that kiddo. Now we're going to hopefully clarify that, but it makes little sense to us when everybody's paid for it and when they're going to continue to say that we either tell that kid you can't take it or do all the FAPE providing we've talked about before. So I think a sensible answer, and I talked to some community college folks on that. That's one of the questions we plan to submit to the department for continued guidance as we move through this. I give the family the opportunity to continue. I would make clear that we can help pass along information. We can be a conduit. So let's put that in the box right here. The instructor for that, the person teaching that, was at the college, right? It wasn't one of your staff members. I think we have a somewhat different question, although I don't necessarily know the answer is going to be different about. It was our teacher at the high school that was teaching it. We were getting college credit for it. Because clearly that would be providing some sort of instruction, right, to those kiddos that were taking the dual credit classes. So what I think you're going to have to do is talk to the community college or the institution you're working with about, can we, as part of your plan, because they're all scrambling too, is there somebody there that we can hand this course off to that carries the appropriate credentials to finish them for the last quarter? Because if you can do that, or if we can find some sort of substitute, co-teach it, or maybe some sort of online programming in a related class that they have to finish it out, right? That's the best option, because then you don't put your staff member into an instructional mode for those kids. If your staff member is the only one, right, that can finish out that class, and there will be some schools, I think you should still reach out to the college and say, can they come do this through all of your circuitry, right? You guys use Blackboard, we use Canvas or something else. Can we get them over to your circuitry, have this staff member work through you, because we're not planning on having all of our staff do anything other than enrichment activities. I think that's the best solution. We do not know the answer of, no, the only person that can teach it is your high school English teacher. So therefore your high school English teacher teaches it, or there's no college credit. I'm hoping we can avoid that with those discussions, but that's the only case that I'm not sure. I think you'll be able to continue dual credit, hopefully, without much interruption, as long as you force that into the community college or university's system that you're working toward or working with. I'm not sure about if our staff member has to continue teaching it, but we're, again, asking for guidance on sort of that subset of these dual credit classes.
Two things. Number one, remember, if they're just getting college credit for it, the teacher now can be a professor. They don't have to have a teaching certificate. So if we're just giving college credit, the community college should be able to shift that to one of their adjunct faculty, at least on paper, because we don't have to have someone who's credentialed to teach high school to teach a just college credit class. Secondly, remember 504 applies to higher ed. So a student who has a visual impairment, a hearing impairment, some kind of mobility impairment, they are going to need accommodations. If accommodations are necessary for them to access that dual credit course, they are going to need accommodations, and that obligation runs to the higher ed entity.
Okay. We have paras helping get meals out to families. If they contract coronavirus, is the school liable? Which is a very interesting word to use.
Who wants to do work comp?
So yeah, I was gonna say, there's kind of two issues, right? Whether the school's liable, that implies some type of lawsuit from them against the school. Typically claims from an employee against an employer are subject to the workers' compensation system, right? So the grand bargain is that there's a regime where injured employees have a claim that they get compensation for, but what they've done is they've waived their ability to sue their employer. So it would be handled by workers' comp. We've looked into this a little bit, and when an employee contracts a disease as a result of something unique to their work environment, like let's say somebody's working in a shipyard and they contract an asbestos-related lung disease, then that might be subject to a work comp claim. But when it's something that's just generally prevalent in the environment, it's less likely to be covered by work comp. It would really depend on the specific facts of the situation. And I think, candidly, causation would be a real issue here, right? So it wouldn't be the legal theory. It would be, she says she got it when she went to that kid's house to give the services, but how do we not know it wasn't at the grocery store or somewhere else, right? So it's a long way from being conclusively liable. There might be good arguments that it's not even something that should be subject to a workers' comp claim. But the answer, like a lot of answers to legal questions, is it really depends on the facts.
I think it's going to be really hard for someone to prove that
Causation.
when we've closed the entire country because this is so highly contagious, unless they can prove that they were wearing a body condom, except for the time they handed the lunch bag to the kid, it's going to be impossible for them to prove causation. We're getting punchy here, so we got to roll with it.
Do you want to say what that? You should reach out to the community college or the college, university system college that you're working with.
I got a text from somebody that said that the college they're working with basically said, it's on you. You treat it the same as the high school credit that you're doing. Here's what I would do. Reach out to them.
I would find the student that's taking that class with the most aggressive and well-spoken parent, and I would tell them, if you don't get that college to change their mind, there's nothing we can do. That's what I heard. Okay. We have paras help, and we already did that one. What do we do about IEP meetings and MDT meetings that are currently scheduled? Do we continue to assess students for MDTs? Do we have IEP meetings to meet compliance issues? What if we sent out a consent, but it hasn't been returned yet? Does that do anything to the timelines?
I think that timelines are weird because they're least likely to be waived. I do not think the U.S. Department of Education is going to just say, oh, don't worry about those timelines. But they are also going to be the least likely for us to get sued for or a legit OCR complaint about. So if you have sent out a consent for initial evaluation and you're within your 60 days to get that initial eval done, and you cannot assess the kid because you got to do the Wyatt face-to-face, your timeline is going to be stayed, is what the guidance from OSER says. Now, if you're doing something that is like everybody fills out a scale and then the school's like just completes it, like the FAST, then I don't think your timelines are automatically stayed because there's no need for you to be face-to-face with the kid to get that evaluation done. So I think with anybody that you're in the middle of an initial eval, I would love it if you would reach out to those families and get in writing either an agreement to revoke consent for the moment and with a promise that we'll start back up as soon as we get back to school, or some kind of game plan for the fact that it's impossible for us to meet our timelines, and here's what we're going to do about it. Regardless of which of those two things you do, we're going to have to support that with prior written notice. Quick footnote, we have a long list of all the prior written notices, like different forms that you're going to need, and we're going to start rolling those out. We have other crises coming, but we will get those out to schools to support you as soon as we can. So that's initials. Triennials, we have, if you're going to do a triennial and you weren't going to do any evaluations, you're just going to do a file review. I don't think your deadline's waived. Amy's with me. If you did need to do a new court, I feel so smart when I say these things. I have no idea what I'm talking about. So if you were going to do a new court or KTEA or whatever,
that's recorded.
And you have to have the kid face to face, then you're gonna be in the same position as you are with your initial, that you're gonna have to reach out to the families, either see if they'll waive or just send a private notice saying that it's impossible or impracticable. So that's that. Annual IEP meetings, because it's coming up on IEP season where everybody meets in the spring to worry about next school year. Your annual deadlines are not automatically waived. Now, usually the entity that hammers us for not getting things done on the perfect timeline is the department. Department file reviewers love nothing more than counting to 364 and tagging us if we don't get that. I feel very confident that the department is not going to be super aggressive in enforcing perfect 364-day compliance. But you can't just say all IEPs are on hold. You cannot say, don't worry, there's no MDT, no IEP problems. So if you have upcoming IEPs, you're gonna need to reach out, either try to schedule those meetings telephonically or via Zoom, or see if you can get written consent from the families, either to waive or to amend just in writing. And we'll be working with your special ed staff as aggressively as we can. But yeah, I don't, one last thing, and I bow to no one for taking shots at the union. But I also want to give props to Maddie Fennell. I think the Facebook Live that she did was a legitimate response to the fact that her members had questions. And we're all going as fast as we can. Everybody's making mistakes. So this is not me criticizing Maddie, because I think she did the right thing Sunday night by having that communication with her folks. But Maddie misspoke. Maddie said, don't worry about IEPs, don't worry about MDTs, that's all on hold. And that's just not true. Amy reached out to her, which I think was also the right thing for Amy to do. So we're all doing the best we can. So I'm not taking a shot at Maddie, but when your special ed staff tells you, no, the union told us we don't have to, that's because Maddie misspoke. And they cleaned that up with an email out to their staff, but you guys should just know that that did happen.
I don't begrudge anybody trying to figure this out on the fly either.
I thought, like I say, like I tweeted on Sunday night, I thought it was well done.
So just a quick reminder, I know some of you have board meetings and all that. We're just going to keep going because we're gluttons for punishment. If you have to jump off, it'll be recorded. We'll post it. We'll also have the log of the questions. So if you want to kind of footnote, oh, here's where I left off at the hour and 8-minute mark. And we're going to get to all the questions in the document you submitted. There's going to be a lot of repeats starting, so we're hoping it doesn't take too much longer, but we're just going to keep going, right? So just so everybody knows that.
And this will be recorded and up as soon as we get it up.
How does special ed IEP minutes look for service time?
Are we doing enrichment or are we doing education? I think if we're doing full-blown education, we're gonna have to tap dance really hard, because I think it's gonna be really hard to meet our minutes. If we're doing just enrichment, then the minutes are on hold because we don't have a FAPE obligation. Regardless, I'm pointing at Amy here because I know this is right. Regardless of, like, somebody that's got speech, that's easy. If we do full-blown education, you're gonna need to get that speech path on telehealth and get the services in. If we're doing enrichment, you don't have to get the speech path. Regardless, when you meet for that kid's IEP this fall, you're gonna have to talk about whether there's some sort of additional speech service that this kid needs because everything got jacked up because of coronavirus.
Amy, please.
But we aren't saying that, so say it's your normal day is 8 hours and you typically provide 4 hours of educational service. So it is a prorated, and you need to look at, so if your e-learning or your platform is to provide at least 2 hours of educational opportunity, then you would
Prorate those
proportionately
minutes.
make those minutes available.
Yeah.
Service-wise.
Just quick repeat.
Amy pointed out that if you normally provide like 6 hours of educational services and you're only gonna provide 1 hour of educational services a day, you would prorate those minutes down to 1/6 of the minutes that would have normally been provided.
Your enrichment and special education explanations seem to go into a full circle. Then you're understanding us
Thank you.
perfectly. Enrichment if we're only enrichment activities, do we have to comply with Rule 51? It's not that simple, which is why it feels like a circle, because of all the stuff we just said. There are some things that will not stop that are in Rule 51, no matter what you do, right? That's the important thing to remember.
Here's the short answer. You can't say, hey, you disabled kids, go in the basement and play Fortnite. We'll see you in August. If you're gonna do something for your gen ed kids, you need to provide those similar opportunities to your special ed kids. Now, if you are only gonna do enrichment, you don't have to send the OT and the PT, and you don't have to have a phonological awareness Orton Gillingham expert doing reading. Like, there's all that stuff that we spend a lot of money on, honestly. You won't have to do all that, but you'll have to give something to the kid that is the same or similar to what you gave typical developers. I'm sorry, I know.
Nope, this leads into this question a little more.
And again, you have the 504 ADA access issue, right? Even if you're not providing FAPE under Rule 51, you have those federal requirements for access.
Kendall says a little more detail on the ADA requirements, please. That's exactly it. Even enrichment activities are still covered by and must comply with the accessibility requirements of those laws.
And students who are visually impaired are the easiest example. If you are sending home paper worksheets, you either have to send a Braille version or a large print version or some version. You can't tell the blind kids, sorry, you can't see those worksheets, so you're just screwed.
If 45 days are still a requirement for evals, can we ask, say, one student at a time to come into the building to test?
I think you could. The guidance from OSERS says that you don't have to, but you could. I think you could.
That's a question from an ESU, so it's a yeah, probably one that came from their members.
Oh no, Steve Williams wants to
And
chime in.
it depends on the basis of the school closure.
Yeah,
Right?
that's true.
If public official says I don't want no warm bodies in there, even the superintendent, maybe it's no. If it's a voluntary closure, you might have more latitude.
Karen, what is your definition of full education? 45-minute periods, 8 periods a day?
The guidance says any educational services, which is why we got.
I think if you're
Where we
doing
got?
an hour, if you say everybody's going to log into Google Classroom for 1 hour a day, I think that's full. And you're going to teach new concepts. I think that's full educational services.
I don't even care if you use the word full. Just take it out.
Yeah,
That's
that's right.
educational services.
And those of you who are special ed nerds who were on the OSERS call with whatever her name is, Vanderfluge, like you could see this question got asked by national special ed people over and over and over again. And she kept coming back to, if it's education, you owe faith. How many times did she say that? 15. So.
Enrichment seems appropriate for 2 weeks of closure, but if we go beyond 2 weeks, are we going to need instruction? If you're closed for 2 weeks, Grizzle, you'll knock me over with a feather.
Yeah, so I would just say this, when we're talking about right now and we feel pressure to get something out because people want to know what's going on, but we have to hit the brakes, stuff lined up. I think that's right. I think doing nothing and getting a good plan is right. But what I would say is, and the OCR highlighted this in the video that they released today about the things they're going to require so the special education students have access, is that even if you don't have a solution for now or for April 1st, I would start to think about how you are going to ramp up the online resources, ramp up the access, and ramp up the things that seem really burdensome right now, so that if you're having to be online May 15th, June 15th, August 15th, October 1st, we may be able to pause to the end of this school year, but that doesn't mean that it's going to be addressed. So I don't really think it's an either or in terms of providing special ed students with what you need or just stopping forever, because I think my strong suspicion is that the politics, the resources, and the spread of this disease are going to mean that you can't be on hold forever. So even though I know all of you are drowning in emails for vendors that you can't stand their sales staff, if you run across one that's maybe a good idea, maybe flag it not for this week, but for something that may help you with the solution to meet these things, because it's not going to be okay to just push pause for 6 or 9 months.
So here's a good point. I believe the guide, and this is again about reading it and what's it actually say. I think the guidance from the CDC is to cancel gatherings of more than 10, especially if they serve higher risk populations. All this is guidance until it's official.
The guidance
That's
from the
what we
Surgeon
keep
General
saying.
is not to smoke, but they don't arrest me if I buy a pack of cigarettes. I mean, yes, I agree we shouldn't be having gatherings of more than 10. There's a difference between what's unlawful, that's our job, and what politicians want to tell you, which is the CDC's job.
Many thanks to NDE for the guidance that we've been referring to. When can we expect it? And if you don't know, that's fine. I mean, it's a couple people have asked. Hopefully tomorrow. We're all building the airplane as we fly it. So let's say we're out for the rest of the year. At the elementary level, we have social promotion. It's just up to us to figure out how to catch up.
Yep.
I
And
think-
this is the example we were talking about in my office. Like if a kid has cancer and this is a whole semester of school, you are not marching through 15 math problems for every concept that you're teaching, right? We do essential learning, we do compaction, we do whatever the other word is that I can't think of for high ability, compression and compaction or whatever the heck it is. But so I think we're not going to have to march through every worksheet in the curriculum to get that taught. What do you make it? What is
You
it?
pulled out your EduSpeak thesaurus before we rocked in here.
What is it? It's like, I don't know. We haven't had HAL regulations for a long time.
Okay, can we provide credit recovery while students are out of the building? Kind of asked this, but just to reiterate, I know that's when we've gotten a lot. Is that instruction? Is it non-instruction credit recovery that's happening when students are out?
That is not special ed.
That is not
But if
special
you
ed.
provide credit recovery, do you now have FAPE obligations? Sorry, we have,
FAPE obligations, if you provide credit recovery, I would look at the guidance, look at what new comes out from the feds if the pushes can get us there.
I would.
In other words, Jane, I would, and anybody else, I would hold off on that exact question until we get a little more clarity on that enrichment versus instruction and educational service line.
Yeah.
If the board's allowed to waive education or graduation requirements so seniors can graduate, will it also cover underclassmen earning credits for classes? Again, this is one where I know the commissioner's referred to his concepts about do we freeze everything? What do we do? If we don't, are we going to do a pass-fail system? I think there are going to be a lot of options out there. I don't know what the answer
I also
is.
would be, and this is not a shot at Matt at all, I would be a little leery of saying the commissioner said in this press conference on this date that we're gonna freeze grades. Like, we're all, I think sit tight, we don't know the answer yet.
So this is just a comment. And I think we're getting a lot of these same comments. So all of you, I think, are on the same page. I think our parents can buy a couple of weeks of sitting tight, enrichment activities and those sorts of things, but they may have an expectation that we move forward. I think that's pretty much what the commissioner is saying he's hearing already. The one thing I would say is that's great. And if any one of those parents has a full and complete understanding of the ADA Section 504 and the IDEA, invite them into the decision-making room, because that's the tough part.
I would say that I wasn't on the Zoom call with the commissioner because I had an IEP team meeting. But I would say that the commissioner would really like it if you would not go out to your community and say, we would provide full services to your kid if it weren't for those goddamn special ed kids. I think throwing the special ed kids under the bus is not okay.
We're getting into some practical questions.
No.
We have a staff member already out on maternity leave currently. Will be out until April 15th. We kind of talked about this one. This one came in, I think, from Jason. If you have somebody who's currently on leave and will be out until April 15th, I think the answer is, unless they say, I'm ready to come back and report, right? When other staff are coming back during the closure, they remain on that FMLA leave until it stops. If it's a maternity leave, they have the choice of when to stop it. That's the one thing to keep in mind. What if not all observations and evaluations were done and we don't come back to school?
Welcome your staff back for the 2021 school year.
Then I think the answer is, unless you have a policy that says, for example, a tenured staff member is only evaluated every couple years, and we did that in that cycle, for any probationary, there's no non-renewal if you haven't completed the evaluations. I think the union has been gracious in talking about waiving hearing deadlines and those sorts of things for notices that go out. I don't think we're going to get a waiver of the actual deadlines to complete evaluations. Here's what I'd say. If you come back for 2 weeks in May, though, you can do evaluations after April 15th.
Right.
April 15th is the notice deadline if they're not coming back, but you can still do those evaluations after April 15th.
And the other thing I would say is, if you have somebody that has to go because it's unacceptable for them to be in your district, you can cancel them.
If
Okay.
you have the legal
If you
basis.
have the legal basis to do so. The April 15th deadline is not going to apply. You know, if it's a performance issue and they're going to argue you didn't do your evaluations, that might be an evidentiary fight. But just not having that second evaluation in spring semester, if you have a legal basis to get rid of them, we will help you get rid of them.
Nick, thing I'll add, if you have if you've done the observation, you've got your notes, you either haven't typed up the full evaluation into the Marzano rubric, or you haven't post-conference with them, contact your school lawyer because I think it's not too late.
I'm about to have a meeting with 11 people present, and now I'm confused. Yes or no? Yes, I think you can have it. There's no law saying you can't. The CDC recommends that you don't. That's where we are.
Yes, you
Part
can.
C includes a service coordinator. If our service coordinators are reaching out to their families during the 2 weeks the district is closed, are they putting the district at risk of this slippery slope of enrichment versus full educational services?
You don't think so, do you?
Non-educational early intervention.
Yeah, that's it's EIS, so yeah, it's not, no, go ahead and do that.
Have the conversation with them, but yeah.
So yeah, Amy makes a great point,
Yes.
and the guidance is super different for littles than for kids who are school age. So EIS, pretty much if the lead agency is closed, your EIS obligations are suspended.
This is a really good question. How can we adequately and fairly grade and assess students if we provide instruction and curriculum in the formats we're proposing? Should it be pass-fail for the possible quarter that we may be providing e-learning? I think that's core local district decision-making right there. I think totally you can, unless I'm not understanding something about the state standards for those hours.
And that's one of the reasons why I don't think we should be promising that we're gonna do full-blown e-learning right now, because I think those are questions we're gonna have to wrestle with in the next few weeks.
Should we hold off on having board meetings to address employment issues and superintendent authority under the executive order? Really good question from Dale. The short answer is you can still have your board meeting. I think there's a good reason to have your board meeting, even if now you could also have one next week if necessary, telephonically. You can cancel it, no doubt. And you can 48 hours from now with the appropriate notice, hold an e-meeting. You should contact your school lawyer about the requirements and authority to do that. But again, if the question is, should we hold off on broad sweeping authority to the superintendent because we can have e-meetings? That's a discussion with your board president.
I will point out, if this thing is gonna be as bad as they say, and 70% of the population gets it, even e-meetings if someone is too ill to attend, you may not have, I think still having that authority to the superintendent is gonna be an insurance policy you're glad you have.
That's right. If 3 board members are hospitalized,
Yeah, you don't have a quorum.
you don't have a quorum, even if it would be telephonic. Let's see. If the sub is teaching dual credit classes and need to teach the college kids, is that different?
Oh, what if they see the bullet coming? Then it's an assault too.
This is for those of you that haven't been to law school, this is what law school is like. It sort of is. I mean, only it doesn't go on for days and days.
It goes on for 3 years.
Let's see.
I don't know. Did we answer that question? Do we
No,
know the answer?
I think the short answer is if a sub is teaching the dual credit class, my hope is that sub could continue teaching it for the college.
Yeah.
I think that's the answer. And if the college isn't willing to play ball, that's a political problem, because I believe that they've got the mechanisms and authority to work with you on that if they want to. I'm not saying that bend them to your will, but I do think that that's what would ideally happen. Materials sent out. Can we expect completion with no grades, just not required?
So what do you do if they don't complete? Slap them? I mean, you can expect, if there's no consequence, what I'm saying is if they don't turn their papers in, if there's a consequence, I think it's education, right? If they don't turn their papers in and you don't consequence them, then I think it's enrichment. Am I wrong?
This is a super important question. Is it a metric or a standard shit ton? If a high school student is taking dual credit course from a college using distance, can they continue? I think absolutely.
Yes.
Talk to the college to refer the parent to the liaison at that college to shepherd them through.
Yes.
Okay, Steve. I'm not even asking that one. Karen isn't coughing as much today. That's a good thing.
Thank you.
Dual credit we talked about.
I will say my youngest is home from college, and those of you that were on the the special ed director's call this morning got to see him parade behind me without his shirt on. So welcome to my world. He told me last night that his girlfriend wanted to hang out, and he was kind of scared because, Mom, you're coughing a lot. And I was like, yeah, I think it would be dangerous. She can't come. So a little cough might be in my favor.
Did you get asked to leave your own house by your son who's home from college?
Yeah, I kind of did. Yeah. Quarantine yourself at the office, Mom.
Return to work agreement is still technically paying for services not rendered. Isn't that illegal?
It's not.
So this is, I'm not going to say who it was. We can fight about it later, Grizzle. But here's the difference, in my personal opinion. And I know that there are people listening to this that may disagree with that. That's totally fine. We got people sitting in this room that may disagree. The idea of a pair that wouldn't otherwise be working. We are going to pay you to be on our ready call to come in and work if we find so. If it's a 65-degree day tomorrow and they can come help do something, then we're going to call you into work. We also don't want to lose you because we train you in a significant number of ways. You're familiar with our special education students. You know not to touch little Steve on the shoulder because he freaks out. That's a whole universe of stuff that you cannot just replicate by rehiring after the closure. Whether your Board of Education agrees with that, whether that fits with your community expectations is a whole separate thing. I'm unwilling to take it off the table as an option. As long as everybody understands the risk is that the auditor comes in or the AG says you should not have done that because you didn't have enough bang for your buck when you paid them. I think you get a lot of bang for your buck for that, but that's the fight, right?
By the same logic, you could not give sick leave. Isn't that paying someone not to work? Isn't paying someone not to work during a closure so that you can have them back and continue to fully fund your staff exactly the same benefit structure that you have for sick and personal leave? I think that argument proves too much. And I will tell you this, I understand completely the argument, and I think really good lawyers that read the Constitution carefully have identified the problem. But I don't think you can reopen in August with 0 cooks, 0 bus drivers, 0 paras. If the commissioner's pissed now, he's gonna be super pissed when we're not staffed with our classified staff.
Okay, can you expect your custodians to work in your, but not your paras and still pay your paras as normal? You can assign their duties and hours at your discretion. So that's why I said a lot of schools, to avoid this question, are gonna put those folks to work some way, somehow, in a lot of different ways. So yeah, absolutely.
The one thing I want to point out about that is you can reassign classified staff different duties, but if you're aware of something that's a disability, like maybe you've already incorporated a reasonable accommodation into their current job, and now you're going to assign them to something else that you know is going to violate that. I'm not saying you can't, and we can't look into it, but it's something to be aware of, and I wouldn't just do it willy-nilly with everything, because it may trigger a disability discrimination issue that you wouldn't have had if you just kept them in their normal jobs.
Student displaced due to quarantine or for other reason is now living in our district, even though they didn't start in our district. Are they homeless? Do we need to provide whatever enrichment or educational services we're providing to that student? And are they in your district for the time being? What if they leave in 14 days?
Number one, the homeless designation would not get them transportation because you're not open. So the homeless designation simply answers the question of
You're
whether
providing educational services. It's going to be hard to argue that, right?
McKinney-Vento says immediately enroll and provide transportation.
Right.
I guess what I'm saying is it's only a one-pronged question now.
Gotcha.
And I think that the answer is if you're providing enrichment, 1,000% I would enrich that heck out of that kid.
Yeah.
If you're providing education, I think you're probably not going to win the 79-215 sub 1 or sub 5 argument. So I would enrich that kid.
Yep.
And if you're having school, I would educate that kid.
Yeah, because they get a pick for residency purposes, which is a different question of what
homeless.
serve. Yeah, that's right. That's right. Let's see. So this is a fair question. Why wouldn't schools strive to provide education activities that would create new learning for students both in general and special ed? In special ed, if we're not able to achieve fully to parents who have access to the IEP processes and protections to request comp services and other remedies. So why are we afraid of it?
Look, that was sort of what I opened with. It's our job to give you options, and it's our job to tell you what minimum compliance is. That's the lawyer's job. If whoever articulated that, if that's the philosophy of your district and that's what you want to do,
Let's do it.
that's awesome. And would I choose to put my kid in your school district if I had school-age kids over a district that was going to do nothing? Probably so, right? But it's not my job to make that policy decision for you guys. That's your job.
That's good. That's a good aspirational goal. In fact, as time goes on, I would hope that that's most people's aspirational goal. I think what the guidance from the federal government would say is that until you've ensured that that's a reliable way that you're going to do it for all kids, you can't ignore your obligation to special education students. That doesn't mean don't do it. It just means everybody rushing out to just start cranking something online, whatever the quality, I think needs to tap the brakes a little bit. That's all we're saying.
Does asking Amy, please.
And it would be our job as a Department of Education to guide you to do just that.
There you go. Yes.
And then have your lawyers tell you how to do it right.
Right. Yep.
And I'll just keep saying that over and over, but eventually we're gonna have whoever posted that provide us with their model so that we can say, hey, everyone, this is how it could look for you.
Yeah.
I think that's the struggle right now. No one knows what it should look like, except for obviously some people do. So we just need to share.
And the should in terms of best practice, not should in terms of minimum compliance. So that's, the technical assistance that the department gives you is not always the bare minimum, which is that. So we have different roles, which is, again, why I'm really delighted that the department, Amy specifically, that the department as a whole has been so collaborative with us all.
Does asking certified staff to check email regularly from home count then as duty days?
I do not think so. We are permitted to have them check like on a snow day to see if, we're having a staff meeting tomorrow. So I don't think that makes it count as a duty day, but anything beyond that, I think we start to cross the line.
I think
y'all agree?
if they're checking email to figure out who has to come in, if they're checking email to figure out what assignments are for tomorrow, I think that's different than while you're just sitting there, binging Netflix, why don't you review this curriculum, right? The question is, what emails are we sending?
And I don't think you can, at 2 o'clock, say, I sent you an email 45 minutes ago. Why haven't you got back to me yet?
Yeah.
Right? I think it's kind of like a daily keep up to date with what's going on.
Yeah, that's a question from Katie. It's a really good question. And the fact of the matter is, your fight is going to be with the union about whether that counted toward 185 or not, if you're going to add on to the year.
Right.
So if at some point you realize we're not going to add on, or what we're going to add on is certainly not more days than we need, okay, then we count it, right? But I think you got an argument it isn't unless you're asking them to do something.
Jordan Johnson is at home in self-isolating. He checked, he says there's still nothing on the governor's website about the executive order yet, so.
Thank you, Jordan.
Yep. Commissioner said, that's not a question. What if our staff person teaches a dual credit class? Amy, that's the one that we're asking for guidance on. We don't know. Because if they're teaching as part of the college, right? If the idea is we're switching them over to the college's infrastructure, then they're teaching for the college for this quarter. They may be getting paid by you because of the statute, but they're teaching for the college. Whether we can build that wall in between is the question. We don't know the answer to that yet. Can enrichment be graded or not? Does it impact whether it is enrichment if it's graded?
Yes. That's a short answer.
It does impact it.
When you say graded, I guess, are we giving the kiddo feedback? 2 times 2 is not 5. Nobody has. We could do that, but if we're grading and then creating a record by putting that in a grade book or power school, then I think that's education. Would you agree, Amy?
So if I'm an instructor and I have to help that student understand it, I would say that's an educational opportunity for a student.
There you have it. If you're grading it, that pushes us dangerously close to education is what you're saying. Yes.
All right, we're gonna flip.
That's why you wanted maybe an app with a buzzer noise instead of a little ding, and then we can give the kid immediate feedback anyway.
Like the slot machines.
Yeah, just
Ring.
All right, for those of you, there's a bunch more questions we'll get to. We're gonna flip to make sure we haven't missed any from the Q&A document that you all submitted. Let's see. Certified staff who also drive routes. If we pay other classified staff, do we need to pay these certified staff the compensation for those routes?
I think that's part of their regular salary.
So then yes, if it's
Isn't
usual
it?
salary.
That's what I'm.
If it's as part of their usual salary, which is what the statute says. So this is a similar question to what about extracurricular assignments? If they're the track coach, but they're not performing. So I would be inclined to decide, is that part of their usual salary? That's what the statute asks you to consider.
So
what's the answer? I mean,
Keep
But if,
that.
but if it's
If
not
we're
extra
paying
duty, not part of the negotiated agreement,
If
isn't
we're
it
paying
not
them-
part of the teacher? It's
we're
not
paying
part,
them by the route.
it's not unit work.
What does the statute say, Steve?
Sorry, I'm muting somebody.
798106.
If
A
we have
teacher that drives
teachers
the bus route.
teachers who drive bus route, is that part of their usual pay? The short answer, to be
I'd say
perfectly
no,
honest,
because it's not unit work.
well, to be honest with everybody, we don't know the answer. We know that the York versus Neal case said coaching is not teaching. So if it's teachers who are covered and it's their usual teacher pay, but there's an argument, right, that their usual pay is what you usually pay them. And if you're usually paying them to drive bus or perform extracurriculars, so those are the two arguments. The question to me is, which one does your board want to land on?
It technically says teachers shall be paid their usual salaries.
Okay,
They're not getting a salary for the bus driving work, maybe?
that sounds good to me.
I think, I'll be honest, this sounds self-serving. You need legal advice before you're going to stop paying those. That's the short answer, because the risk to your board is an unfair labor practice claim or a violation of that statute.
Or
and they-
wage payment collection act.
the Wage Payment Collection Act, right? So that the answer isn't clear. You have options. Where do you want to, which lawsuit do you want to defend? I got a lot of schools that said we're going to pay it whether we think it's usual. Our building is a community wellness center. If the
Yes.
board votes to close that facility, do we need to vote to reopen it, or can they grant that to the SOUP? I think they can totally grant that to the SOUP.
Yes, agreed.
And I think that can be based on whatever you want, including just talking to health officials. What responsibility would the school have if parents start to host events? For example, prom without school support because we're closed.
As long as you can say it ain't us, I think you're in the clear.
We hate it. We hate the summer camp problem that it ain't us, but it's kind of us, but they take our jerseys and our basketballs and drive our bus, but it's totally not us. Oh, but the coach is also there, but it's totally, this is actually probably the best chance ever to be clear that it ain't us.
Here's the thing, if they get drunk at that parent hosted prom, you can't expel them. So it's like, it truly is not your problem. So I think,
I wouldn't let them have it at your school facility.
no, you can't have it at school, no.
Well, I don't know that that's going to be relevant with the restrictions that are probably coming down by health order, but anyway, that is what it is. Can you clarify if schools can have employees in the building? If so, is there any increased risk by having our teachers in the building? We have staff that are claiming the governor has shut down schools starting Monday and no one can be in the building. We're planning on having a small group PD that would not exceed the 10-person limit.
This is all the governor has done legally. You can have telephone conferences and video conferences.
One, yes, you can have staff in the building. That's not illegal. Two, the governor has gone to great lengths to not shut down schools, but to bully you into shutting yourselves down. And that's for both practical and political reasons. Number three, I'm a little leery about being a real hard ass and making them come into the building. I mean, we do have digital, I would be much more inclined to do that electronically if at all you could. But I don't think it's illegal. The sheriff is not going to come. The teachers might call the area rep and they may complain about it, but I don't think it's an unfair labor practice. So I think you can do it. It's whether or not that's a great idea.
Again, it depends on the basis for your closure. If public health officials say no, then you can't. If it's voluntary, then you have more flexibility.
But do we have any public health closures? They've
There
suggested
are
it. They've
limitations
encouraged it.
in Omaha, for example.
Oh, yeah, Omaha. Yeah.
I mean, it's St. Patty's Day, right? So, I mean, they were thinking about that.
Lisa just commented that Kansas schools closed for the year.
Kansas schools closed for the year. All right.
That's because they ran out of pennies down there in Kansas to keep the lights on.
Yeah, no kidding.
Okay, here's our office staff and maintenance staff will be able to stay busy doing their normal jobs. I'm hearing that a lot. That's 100%. No, they don't need a return to work agreement then because they're already at work. If we tell the rest of the staff that they'll be doing other things as needed, I'm assuming we're talking classified staff here, like cleaning, maybe delivering meals if that's how we choose to do USDA compliance, and they refuse, then we intend not to pay them, 100%. Would this qualify them for unemployment? I'll be honest with you, I think the answer is they're not really gonna look that closely at this point based on what they said, but I think there's a pretty good argument that they don't meet even the expanded definitions because you've literally told them we will employ you. We don't, but again, until we see that executive order and specifically what it says about qualifications that are waived, we don't know. But that's exactly, I think that's going to be the question. Any other factors to be aware of? Even if they're on a return to work agreement, that's going to tell them you need to be on call and come in when we tell you to. So you should stop paying them if they say no, right? Absolutely. The return to work agreement isn't a get paid and get out of work free card. It's you're ready and willing and able to come in when we ask you and when we start school again.
Yeah, and I had a specific question from another district over the weekend, and what I'd say is you can require them to do that. If they're at-will employees and they refuse to do it, you can terminate them, right? It's at-will. Like, you tell them to do a job, they don't do it, it's your election. You don't have to. You can say, nah, I was just kidding about cleaning toilets. I didn't want to make you do that. But if they say no and refuse to perform the duties, you can end that relationship. What I would say, too, is that while you're thinking about the optics to maybe taxpayers that don't want dollars going out the door to classified staff to not work, and you want to have the perception of, oh, I told that para she's going to paint, right? That at-will relationship, that cuts the other way too, right? You could say, yep, I'm going to have, look how busy I'm keeping my staff. But if the staff you wanted to retain, and that's why you put the work agreement in place, says, I'm good, I'm going to do something else to pay my mortgage, right? You might lose the staff by doing so, which it doesn't mean don't do it. It doesn't mean you don't have the legal attitude. It just means be aware that your ability to get rid of them for refusing to do something cuts the other way too in terms of whether they have to do something they don't want to do.
Okay, do we need a special board meeting to handle this stuff, classified staff and all that? I think so. I think you should do an authority piece on it. I think you should have these issues. But again, your option is to do nothing, not have a board meeting, and then whatever your current contracts and policies say, that's what applies.
Legal theory answer, if the board has already explicitly directed the superintendent the latitude to make all terms and conditions hire, fire all classified staff, you don't technically have to have the board approve it. I think it's best practices too, both so that they're aware of something because this is categorically different than what you were doing before, and also then the politics, right? The board has endorsed it, they've signed on to it. If they get the political heat for it, hopefully it's not on the superintendent for being off the reservation.
And we do have like form agendas and form motions if you want that. I think you guys are perfectly capable of doing that yourselves, and I'm sure the Perry Law Firm or whoever has that too, to try to make, I know the problem is I think people are reluctant to call special board meetings because you're scrambling.
Yeah. Any change in board meeting publication requirements? No, but we think it's smart when you're publishing notices to say if you're going to have an e-meeting, I think you're going to have to do some of that stuff. But again, how you're going to do that is, I think, how you're going to provide the notice. So that's going to depend on your context. We've hit on those, hit on those, hit on that. We had all of our special education staff make packets for their SPED students. These packets were specific towards their IEP goals, enrichment or services.
That feels service to me because you've individualized by selecting the materials that are appropriate for each kid, that feels individualized to me. Now, my question is, if they fill out those worksheets and they don't have a certificated special ed instructor, will that count towards FAPE, Amy?
I would,
I speak, no, yeah, it will, because the special ed staff is the one that picked the worksheet.
I
It's just
think-
like, yeah.
I think if the district decides to go that direction, then they would be deciding to do FAPE. And
I think that's right.
Yeah, I think that's right.
lawyers would help them to know how to legally do that, right?
I think that's right.
Yeah, so the answer to that one is
instruction.
going that route, right? And this is probably a bell that you can somewhat unring if you clarify moving forward, but going that route, I think is probably endeavoring toward FAPE, which looks like education. How do we get, okay, we talked about that. Yeah. What about it for those folks that decide not to come in and work, we're not paying them, and they don't write us a check, so they have to pay some amount for premiums. We can't pay that because there is no check. Do we remove them from those benefits? Well, the short answer is you're gonna need legal advice on that, and you're also gonna need to talk to your plan folks. I think it depends what plan you're talking about. But yes, in general, if they're not working, there is no paycheck, and they otherwise have contributions to make, number one. And also, if they're not working, the same argument about can we provide them pay is can we continue their insurance? So even if they were only paying 10% toward a single, there's an argument that they owe 100% if they're not working. So that's why I think something like a return to work concept or talking about this is important, because it's benefits, not just compensation.
It also may depend on your board policy or your staff handbook. Some staff handbooks have, they have to pay each month, and by a certain time, then we can cancel their insurance or things like that. So I would look at that before just looking that they're not working and canceling insurance.
Yeah, this person says toward the unemployment thing, I've heard that the unemployment benefits will not be the responsibility of the former employer during these special circumstances if certain emergency laws are put into place. This is kind of what they're trying to do. We need to see that executive order. They've said for somebody that's taking unemployment as a result of this deal, that they're going to take it out of the community pool and not out of the community trust and not from you. I'll believe that when I see it. Maybe it'll happen, and if so, that may become a viable option. Yeah, is it still enrichment at junior, senior high if we grade to give credits, even if it's pass or basically no harm? So if it's you can't fail, you can only pass. I think that's gonna get you.
That's education. I'm sorry. And to be honest, as Bobby looks for the next question, we need to get you guys all to a point where you can like continue to operate and pay your bills. We need to sleep, and then we all need to kick it around. We might come up with better ideas than we have right now, but right now is the best guidance that has come out from the Federal Department of Ed is exactly what we're seeing.
Last question on the sheet, and we'll return to somewhere on the chat. There are only a few left. What happens if our school is not over 50% free and reduced, but we choose to provide lunch for all students? My understanding is what you're doing in the interim here is actually more like your summer lunch program. So I think all students could be eligible for that. That was a question we got yesterday. Do employees who may be called into work sporadically still sign the return to work agreement? Example, food service. I think that's even more of a reason to. That's the backstop we have for it. That's the justification is so that they're on the ready. Yeah, right. Absolutely. That's another question from Katie. A good question. Yeah, how do we document if we choose to pay classified staff with respect to the IRS and retirement?
Retirement is to be determined. We're working on it. We don't know.
Yep. And then this other question, because I think what Brent's hitting at here is the right thing. We're not having them clock in or out. We're paying them, right? I think what you're functionally doing is providing additional paid leave, which is what the NPERT statutes contemplate. It says sick, or any other type of paid leave. You're basically in the return to work agreement agreeing to pay pandemic leave when you're not calling them into work is functionally how I would argue it. You know?
Well, the reason I make that face is then that means that this time will not count as service.
No, it means it will. It counts as credible service. Yes. It's paid.
What, section 44? Subsection 44?
Subsection 6, 79902. We'll tell you what, good question. We'll let Oren answer it.
Yeah.
This
we need to
happens
talk
in
about
our
it.
office every day at 4:45. So
Karen, here's my concern. Your comment about a shit ton of compensatory education may be much larger if there are no services in the interim. So to the extent that there may literally not be enough service providers to provide comp ed, assuming that happens when we restart.
that's the metric time. That's the answer to that.
Again, I want you all to hear me. I'm not advocating for any one of your choices on the continuum. I think there are many legitimate choices. My job is to give you all your options. I agree with you, and I think regardless of which option you and your Board of Education pick, we are going to have all kinds of problems with capacity and other issues when school resumes. I agree with that. So I'm not telling you. I'm telling you, in order to take advantage of certain options, you need to understand the consequences of those choices. I'm not lobbying for you to make one choice or the other.
Teacher who wants to do a videotaped read aloud periodically to be shared with students and families. So we checked on this in the past to use our Facebook page. Could be in violation of copyright. Dan Keyser nails it. If it would only be shared on a closed Facebook page for specific grade level or possibly on a Google Classroom format, would that be more acceptable?
Doesn't cure the copyright violation.
Well, if it's an educational purpose and
Yeah.
you shared it only on your page, we got a better
Is there
argument.
an
But
educational purpose if we're calling it enrichment?
that's the question, Dan. Is there an educational purpose if we're not actually providing educational services and it's only enrichment? Man, that's a copyright question that I don't want to have to answer.
Read the book.
Right.
We'll fight. If they sue you, they're gonna look like tools.
Okay.
Which doesn't preclude plaintiffs from filing lawsuits. Just
What if the board passes a return to work pay resolution for classified staff and then the unemployment rates turn out to be a better deal for the district? Then take away the return to work agreement.
Yeah.
Period. That's it. That's a consideration. Then they can leave. There's no requirement that they come in here, beck and call, right? But that's the downside. Can we review content that we taught from the 18-19 school year? I think that's a sort of like similar question, but different to, can we allow like credit recovery?
So we're gonna make sure that sixth graders are really, really solid on their fifth grade skills. I think we could do that. That feels enriching.
I have a 4:30 appointment. Thank you.
Sorry,
My
guys. We're
parents.
sorry this has gone so long.
We're gonna get this down to 2 hours. I promise. My parents are now painters. Why not just give classified staff additional PTO or vacation days or amend their work agreement just for this year? It's the same thing.
Yep.
So you can, if you want to call it a return to work agreement, or if you want to get some promise to give them additional leave, what we're talking about is whether you can pay them while they're not working. The point that we're making is, so whether you call it we're giving you more paid leave, we're giving you pandemic leave, or we're just giving you pay so that you remain ready, willing, and able to come in, it's the same legal backstop that we're fighting about the reality of. So I think that is an option. You need to square that with NPERS,
Yeah.
right? That's the big thing.
I think the one difference is how it looks, right? The return to work is like an ongoing, we'll address the situation as it happens. If you say we're going to give you 20 days of paid leave, because we determine that's enough in the proper arrangement, I think every time you go back and fill that bucket up, it's another political event that you have to fight about. Why did you add on 60 or 80 or 120 days, right? So it's the same legal framework, but the politics might matter.
We have a kid who's working on his truck in the school shop. We want to get it out of there. In our opinion, this is not new learning, it is enrichment. Do you agree? Can we have him come in here and work on it so we can get it out?
Trespassing.
That's not gonna trigger our entire FAPE obligation. Let him come in.
Have the kid pay $1 to lease the shop. That's the short answer.
I love this job.
Jeremy, isn't the responsible thing to do here simply to have the governor cap the spread of coronavirus so it doesn't exceed the rate of inflation? Can we pay paras to work from home? For example, clerical work for staff in the high-risk group. 100%, John. If we sign a return to work agreement, where'd that go? The free unemployment comes, can we end the agreement with new board action? Absolutely. Again, then they're not at your beck and call anymore, because I think they probably can't be. They can leave you. They can decide not to come back. They can tell you no if you want them to come in and work if they're taking unemployment. That's what we need to see. Brian, that's a good question. We need to see from the EO what exactly it means to qualify. Because if you're still paying their insurance, is that going to disqualify them in the first place, at which point you wouldn't rescind it, right? So that's what we need to see.
But what we're telling you is offering a return to work agreement is not an irrevocable choice right now. You can take that away if unemployment turns out to be a better deal for everybody.
Yeah, what do we do with a classified staff member who has said they're retiring at the end of the year, so they won't be returning to come back for work? I think the short answer there is make that person the first person that's going to come in and help with stuff. Get them paid if that's what they need. Make sure they're not losing this year of service credit. I would figure out where they're at hours-wise and check with the NPERS stuff.
But
and
these
do
are
what you
also
gotta do.
probably gonna be people that should not be coming out. 'Cause
I
they're probably
agree.
towards the end of their.
Is
career.
there stuff that they can do at home
Yeah.
to help you to get the hours requirement if that's gonna be necessary? I mean, that's a knowable answer.
We're gonna dance around.
I don't think the actual time frame affects the legality of the agreement, right? It's not just to return to work August 15th. The concept is, if we want you to return to work in April,
Or tomorrow.
Yeah.
or tomorrow, between now and then, we're gonna be under this arrangement. So if they're not retiring until the end of the year, and you want to still get them paid and keep them from coming to the building, you can still use the return to work agreement, because it doesn't presume it's returning next year.
But there are implications for making sure that's credible service and what their separation date is, and that's what we have to talk to Warren about.
3 remaining questions, and I want to see if Amy has anything. We're going to get this done in 2 hours. For the teacher, 4 remaining questions. For the teacher already on FMLA leave, if you're docking their pay because they're beyond their sick leave, should we continue to dock? Because that's the expected date back. If they're able to return to work, then I think you pay them, right? This is one of those that we're going to probably just have to deal with on a case-by-case basis, because to some extent it's going to depend what type of leave they're on. If it is not possible for them to return to work, I don't know how we're going to answer that.
And their usual salary would not be included.
Their usual salary when they're on FMLA leave isn't
the dock,
anything,
yeah.
right? So but again, that's the,
I would probably keep docking it, but.
I think the aggressive approach is to keep docking, but understandably, the union's gonna say, hold on a second. If that person says, I've readied myself for work, then you're paying them, right? But then you should put them into the fold with what you're having your rest of your staff do. We haven't had a summer lunch program in the past year, and they're trying to figure out how to then best provide food service. Do you have any suggestions? That's from Brad. I would contact the department. I mean, they've been all over this issue. I know they've got the waiver. I would contact those food service folks. I mean, everybody that I've talked to said they've been really helpful. So that's what I would do. Brad, I don't know the answer to that one. I don't know. Isn't the NSCA addendum a moot point if we're dismissed from school? It depends. There are a couple schools that thought, what are you going to have your staff do, Shane? To me, that's the question, right? If we're going to do nothing, we're not going to have staff expected to do anything, then you're not worried about the need for them to take sick leave, even though they're already getting paid because of the closure.
But if this is Shane Alexander.
Yeah.
If Bloomfield decides to offer full educational services starting next week, and every teacher is supposed to log on for 5 hours a day, and I get coronavirus, and so I don't log in for 5 hours a day, are you charging my sick leave for that or not? Am I out of sick leave? If I'm out of sick leave, are you docking my regular salary? I actually don't think, I've had this conversation with a lot of you. I do not think closure obviates the need for you to think about how are we handling illness during this time. And again, I keep saying, maybe we'll be back in school. Maybe the Canadians will find a cure. And if that happens, then you're going to have people taking sick leave in the summer. They're going to want to try to burn sick leave because they want to go to Disney World when it reopens. So I think answering that question now is not a bad idea.
Yeah. Do we pay spring coaches? We have community members who coach spring sports. Do we still pay them? I think for community members, no, because they're not working.
Except they have done some.
If you had 2 weeks of track practice, I would figure out what 2 weeks is as a proportion of the total weeks. Because remember,
Yes.
this isn't how many track practices. This is FLSA. This is work weeks. What percentage of the work weeks have they worked? I would pay them for those.
Yes.
And if they're teachers, the answer is you've already been paying them likely
All year.
12 months all year, right? So copy one of Karen's famous phrases, is the juice worth the squeeze? Are you going to run into a potential claim over, $850 or whatever the stipend is?
or whatever, yeah. And the other thing about teacher coaches is, can they argue that they've been coming into the weight room, that they did a camp last summer? It's going to be, for community coaches, real easy to say track season started on whatever it was, March 2nd. And so you work X number of days. But for a teacher, it's going to be a big, I'm not sure that fight is worth it, if you want my honest opinion.
Okay. Sorry, Brad said they've been calling NDE. I'm sure NDE is swamped. Keep calling.
Yeah.
Can we deliver lunches to only students who qualify for free and reduced lunch? Do we have to offer to all?
Yes, you can offer only free reduced unless there's some change to the regs.
So
that
here's
I'm not aware
what
of.
I don't know about, and I wish Jordan was here because he'd probably know. Our newest lawyer's been looking into this. Sadie, that's a good question. We'll try to track that down. I think the answer is,
Yeah, Jordan's watching. That's why I pulled up my phone to see if Jordan would.
yeah, Jordan, text the answer if you know that. But I believe what you're doing is running your summer food program, and that's not limited to free and reduced lunch students, I think. But I don't want to say that too definitively.
Jordan says no, I don't think so. So Jordan, you were saying that you may not deliver lunches, you
Only if
cannot
they're
limit
used.
it. That's, I would trust
Yeah.
Jordan, he's been in those rigs.
Jordan says you can't limit it. That's my inclination. You should probably still confirm that with NDE because they're the ones that got the waiver. I haven't personally seen that, but my understanding is that's sort of what is happening is we're implementing the summer program now during the closure.
While Bobby checks for questions, Amy, is there anything you want to say or you want us to talk about before we hop off this call?
Thanks.
Okay. I just want to shout out again. I said rude things about the commissioner this morning and I felt bad because I said I wanted to punch him and that probably wasn't very nice. So we do really appreciate the department's collaboration and how everybody's trying to figure out how to do stuff.
Yeah, thanks everybody. And again, we've got a lot of questions coming in here. We'll continue to field them. So a couple of things. This will be recorded and posted. We do plan to send all these special education related questions kind of centralized to the department because they've asked for us to pass along these good questions. We'll do so. We'll continue. If you have other special education questions or any thoughts on how you're planning to provide a FAPE, if you're moving forward with this, that would be super good to hear because I think there's benefit in everybody talking about it as usual in this state. So pass those along to us, pass them along to the department as you have them. They're trying to answer as many of these as we can, but even knowing what your questions are helps inform those discussions that they're having at the national level on these issues. So keep passing those along. We're trying not to over content and over webinar you, but we had just a ton of people ask for it. So if you've got thoughts on, any of this stuff that we're doing, let us know. We want to hear it. Do what we can do to help.
I would just say, to echo what Karen said at the beginning, I really appreciate all your efforts throughout the state. And I know everybody's slammed right now and running around like chickens with their heads cut off. But to a person, the clients that I'm speaking with have just been so generous with their time and grateful and really collaborative about trying to solve tough problems together. And so I really appreciate your spirit of service and my interactions with you.
Okay.
Okay. Thanks, everyone.
Thank you.
Bye.